Good afternoon, and thank you for joining us today at this webinar on the UAE Labour Law. This is the third of a series of update webinars we are holding this week. As you can see, Charles Laubach will be leading the webinar and the discussion. I kindly ask you to submit your questions in the Q&A box and not in the chat box. And we will be monitoring questions throughout, and if, depending on the flow and the discussion, we might be pausing in the middle of the presentation to address some of the questions, but most of them will be addressed at the end of the webinar, and we will endeavor to keep it at 45 minutes. Thank you very much again, and over to you, Charles.
All right, thanks very much, Samra. All right, everyone, I hope the audio is okay. The only microphone really should be mine, and at least the people I've spoken to say it's okay. So if you have any audio or visual or tech complaints, just again raise those in the Q&A and we'll see if we can fix them. But at least you can hear me clearly. Well, that's good to know. Okay, let me start. I'm going to talk about the new labor law, which is the federal decree law that was enacted at the end of last year and is scheduled to take effect very soon. Let's see. A week from today, huh? February 2nd. So it's just around the corner, folks. Let's go to the next slide, number 2. Our firm, Afridi Angell, is the longest established independent law firm in the UAE. We've been here since 1975. I myself have been here since 1986. We do pride ourselves on having that kind of perspective that only a long tenure in the country can give you, both regarding the firm and also regarding the individual lawyers in the firm. Most of our people, if you know them, are committed to this part of the world and are long-term residents, long-term parts of the community. So that gives us some perspective, and the fact that we tend to get our lawyers from the best financial centers, the best law firms, the best firms. And we have a commitment, again, a 45-year commitment now and running, to delivering the very highest level of legal services. So turning this to slide 3, that's the context for all this. We're trying to, now I know not everyone out there is a client, but we hope at least you're well-wishers. And I hope that I can provide a little bit of insight and maybe hear some insights from you on what's happening out there with regard to the labor market. Now, this is going to focus mainly on the employer's point of view, okay? Most of our practice is employer side, management side. That's kind of how it is with large law firms. So I will give you mainly the employer's perspective in all of this. We're talking about 2 statutes. The most important by far is Federal Decree Law number 33 of 2021. I can talk about what a decree law is as opposed to regular law if anyone really wants to know. But this is the new labor law, the new law governing the employment of persons in the private sector in the UAE. It replaces the 1980 statute. So 41 years, 42 years went by, and now we have a new law. It's not a complete departure from the previous regime, but it does have some changes, okay? Now, Federal Decree Law 47 came out also at the end of last year. It also takes effect a week from today on the 2nd of February. And that law is designed to provide some rules that are supposed to harmonize the employment rules as between the public and private sectors. I'm not entirely sure what this is about, but it looks like it's an attempt to make employment the same regardless of which direction you go, public or private sector. And to have, so you don't, if you move from a government office to the private sector, you don't get suddenly a different package of entitlements, a different kind of payroll package from before. There will be differences, of course, but I think that's what it's designed to do. It also, I think, for me, you can look at 47 and maybe look how use that to interpret what's present in 33 as well. What I have not put out here is that there are going to be some implementing regulations. They haven't been promulgated yet, but the statute gives the cabinet the authority to promulgate implementing regulations. And given the pace of change in recent years, I would expect the cabinet to act pretty quickly on that. I think we're going to see regulations on this in early February. I don't think we're going to be going along without having regulations detailing the nooks and crannies of the labor law. So let me go to slide number 4. I'm not going to, I could take out the labor law and go through article by article for you, and I won't do that because that's not useful. I want to give you the thematic kind of approach to it and hit first the big issues, the things you've got to do as an employer to comply, and then go through later on the issues that I think are interesting as a lawyer, but maybe not critical for you to take care of in the next week or so. But one feature that is quite important is that the labor law is now going to require that all employees serve under specified term contracts. Now, what does that mean? A specified term contract has a beginning and an end. So if I hire somebody on January 1, 2022, and it's for a specified number of years, 2 years, 3 years, it will end on a certain date unless it's renewed or extended for some reason. Specified term contract. The old labor law had those too, but it also had unspecified term contracts, which have a beginning point but no end. They go on until they're terminated. And the labor law doesn't want those anymore. It is requiring now that all contracts be for a specified term. There is 1 year to comply with this requirement, so you don't have to run off next week and replace all of your contracts, but you should start doing that next week, and you have 1 year to get everything in place. So what? Does it really matter? Well, next slide. In the old labor law, there were some significant differences between specified and unspecified term contracts. And among those were that you could not terminate a specified term contract prior to its expiration date unless you had one of the very narrowly defined causes set out in what was then Article 120 of the labor law, which is now Article 44, reasons of fairly serious employee misconduct. Likewise, employees couldn't just resign from a specified. You were committed for this term of the contract. Now, what the labor law is doing is it's requiring all contracts to be of specified term, but they're also allowing them to be terminated. So if the contract contains a termination clause, termination with notice, then even though it's for a specified term, it can be terminated with notice in accordance with the terms of the contract itself. So that's a big change. That means you don't suddenly find yourself, trapped because you have a specified term as opposed to unspecified term contract. It is one of these little pitfalls that perhaps the law is avoiding, and I think in that sense it's a very sensible change. Now, but the notice period is a little bit different. Now, in the old labor law, for the next week, you can have pretty much any mutually agreed notice period. Most contracts had 1 month. Quite a few had 2 months or 3 months, 90 days. Now, that's the top, 90 days. You can't have a notice period longer than that. It won't be enforceable. And so those of you out there, and I know there are some in the audience that have, longer notices because not at all unusual for senior staff, where you want the extra transition time when someone's going out, right? 6 months, I've even seen 12 months. And those are no longer going to be enforceable. So the labor law is kind of, proscribing. You must have a specified term contract. Yes, you can have it terminable with notice, but the notice can't be less than 30 days, can't be more than 90 days. Now, there is this 1 year transition period I mentioned earlier, during which companies are still going to have unspecified term contracts before you substitute them. Now, if for any reason you want to terminate one of those, the rules change next week, okay? Right now, you can give 30 days notice for a legitimate reason of termination, but next week it's going to be 30 days if the employee has served for 5 years, 60 days if it's more than 5 years, and 90 days if it's more than 10 years. So that's going to be kind of a change. It's an incentive, I think, to get everyone to switch over to the specified term contracts the way the labor law requires. Whether this is going to be contentious, I guess we can wait and see, but that is what the law says. Next slide. Now, Article 120 under the old labor law contained the only grounds that were permissible for the termination of a specified term contract. And it was 10, I'm not going to recite them all to you, but if you go back in labor law, look, it's 10 very, very narrowly defined instances of employee misconduct, coming to the office drunk or under the influence of drugs, being absent without excuse for 7 days in a row or 21 days intermittently. We had a case years ago where an employee was throwing tools around the workplace, and sure enough, someone got injured, and that employee who was engaging in outrageously dangerous conduct was terminated under Article 120. The same provisions are now under Article 44, but there are some differences, okay? Well, number one is that, yes, you can terminate a specified term contract under Article 44. It's going to be difficult like it was before. But there's no distinction between now specified and unspecified term contracts. It's just one kind of contract. Under the old law, if an employee was terminated under Article 120, under Article 44, the employer could do so without notice, and that is still the case. The employer could also withhold the end of service gratuity, and that is not still the case. So the employee, just by being a bad employee or engaging in some kind of grievous misconduct, doesn't lose the gratuity. It's still payable. Likewise, under the old law, if an employee resigned before completing 5 years of service, the employee would forfeit gratuity or part of it. Not anymore. So gratuity, I think, is seen much more now as a benefit for the employee's family. That's how I think it is. And it's the kind of thing that, you know, even if the employee dies, the heirs get the gratuity. So you don't lose your gratuity almost. I don't think the law gives any scope here for loss of it. But those 10 specific grounds for termination without notice, those are continued as Article 44.
Charles?
Yeah, sure. Go ahead, Sam. Question?
Yeah, just because you're on this point, one of the questions that was raised is if an employee resigned and the company had not yet adjusted to the new law, would the end of service gratuity of the employee be calculated as per the old law? Yeah. If it was between before the adjustment has taken place? Yeah.
Yeah. Here's where I think you would analyze that. I mean, the rules, let's say that an employee decides to resign today, okay? Oh, and you're asking about if is the employee going to lose part of his gratuity, his or her gratuity. I see, okay. The answer to that question is, I think not. And I'll tell you why. You've got to give notice in accordance with the law in effect on the date of notice. So if an employee gives notice today, that employee has to comply with the requirements of the law as of 26 January 2022. But the law is pretty clear that when notice is properly given, the last day of service is the last day of the notice period. So if an employee gives 1 month notice or 2 months or 3 months, whatever it might be, the last day of the notice period is the employee's last day of service. And that's the day you use to calculate the end of service gratuity. So if an employee gave 1 month notice today, the gratuity would be calculated based upon the law in effect on 26 February 2022, after the new law takes effect. So I don't think in that case, if the employee, say, served only 3 years, I don't think the employee is going to lose part of his gratuity as a result of that. I don't think so. And I would imagine that if you went to the Ministry of Human Resources, they'd tell you the same thing. The law, in effect, when the termination actually takes place, the governing law at that time on that date, that's what determines the employee's severance pay. Is that the question, Sam, what do you think?
Yes, yes.
Yeah. That's just me. That's just me. I could be wrong, but that's how I read it. And those are the reasons why. That is, different events are governed by the law in effect when those events take place. Okay. It's a good question. It's a good question. And yeah, that's a good example of what I don't think. Now, do employees, are they all going to scramble now for the exit and resign? I don't know. I mean, I think that door is closed. That is, from January 2nd onwards, employees are pretty much protected from losing gratuity just because they resign, because the new law will take effect prior to the end of their notice period. So, that's a question that's been, I think, almost overtaken by events. Can I move on? Well, we were talking about end of service gratuity. So let's move on to slide number 7 and talk about that. This is, let me just say a thing here. End of service gratuity is the same as it was before. Some of the translations of the new labor law don't translate it that way. But that it's the same exact word, same as before. So the same, and I'll get to that question about the calculation for arbitrary dismissal as well. But it is, under the old law, there was a little bit of ambiguity as to what was the base figure to use for calculation of end of service gratuity. Because the old law defined it kind of funny. The old law had a concept of salary, which is everything the employee receives in consideration of performance of the employment obligations. The old law had a different concept called basic salary. And that was the basic salary, but not the allowances, other stuff, okay? Now, it didn't use either one of those for the calculation of gratuity. Instead, it said salary, but not counting allowances and in-kind payments. It listed a couple of things. So it's salary minus a few things. What it did not exclude were things like bonuses and commissions. And so you would have long arguments, and sometimes with big monetary consequences, as to whether an employee's end of service gratuity should be based upon the bonuses and commissions the employee received or not. Now, the new law does away with that argument, because the new law says end of service gratuity is based upon basic salary. It doesn't use salary minus or plus, basic salary, that's it. So that is what you get, okay? Basic salary. And it's the same as before, 21 days for each of the first 5 years of employment and 30 days for each year thereafter. And portions of years count. The entitlement vests once you complete 1 year of service. There is a little bit of confusion in Federal Decree Law 33 of 2021, because it talks about 21 working days and 30 working days. I don't think that, again, this is just me talking, I don't think that means that the calculation suddenly went up by 28%, working days versus days. I think it's meant to be days, and the reason I'm saying that is because it doesn't make any sense otherwise. And also, that's the term used in the other law, the Federal Law 47 of 2021, the one on harmonization of the rules. So for that again, this is just me talking, but I think the formula is pretty much the way it was before, with no ambiguity now about bonuses and commissions. It's base salary, 21 days plus 30 days. If an employee is terminated under Article 44, if one of those grounds for termination, the employee still gets the gratuity. That's a new feature. If an employee is terminated arbitrarily, okay, the employer says, let's say I'm going to fire all the Americans, something that's clearly wrongful, arbitrary. The affected employees can claim for arbitrary dismissal. They get the notice salary they would have got. They get maybe up to 3 months' salary as damages, and they get their gratuity, and they get to cash in their unused annual leave and things like that. So those rules really aren't. You'll see throughout this presentation, a lot of things aren't changed that much. It's pretty much the same. Pensions and savings plans, that is somewhat different. There was, under the old labor law, a provision, Article 140 and Article 141, that allowed an employer to set up a savings plan or a pension plan to replace gratuity. And as you know, if you work in DIFC, there is one of those already in place. And also UAE nationals get the very generous pension benefits from GIPSA or from the Abu Dhabi Pension and Retirement Benefits Fund in Abu Dhabi if you're an Abu Dhabi national. But now the labor law has taken away those provisions that allow an employer to substitute these savings and pension plans and leaves the issue to be addressed by implementing regulations. So we're going to watch what the cabinet does with that issue. It'll be pretty important, but for now, it's gratuity for everybody, basically. Okay, and it's not just gratuity; it's gratuity always. You can't resign and lose your gratuity. You can't get fired for misconduct and lose your gratuity. It's always going to be paid. So, but the basic calculation is similar. Can we go to slide 8, Samara? The big change is the work week, right? What has the labor law done? Now, the federal government announced with big, and it's a big change. I'm having trouble adjusting to a Monday, Friday work week for the federal government, for the public sector. Some other government departments have said we'll go Monday through Friday, but Friday is a half day, so people that have to go to the Friday prayer can do that. The labor law doesn't take that same approach, okay? The labor law keeps the working hours for a normal work week as 8 hours a day and 48 hours a week, just like before. But the labor law does not mandate that Friday be the weekly day of rest. It can be something else. There has to be one, but it can be Wednesday, it can be Sunday, it can be Saturday, whatever. You could even have a 2-day weekend, but it doesn't have to be Friday. So if you want to go on to a 5-day work week like the federal government, you're free to do so. If you want to keep on working on Sunday or working on Saturday, you're free to do so. If you want different parts of your workforce to have different working weeks because of their customer requirements, you can do it. The labor law gives you some flexibility there. So a lot of companies have gone over to the Monday through Friday work week, but the labor law lets you do it, doesn't make you do it. Okay. Annual leave, other leaves. I'm just putting that up there as a kind of an issue. They are continued. They're not changed in a dramatic way. You still have 30 days of annual leave for every employee. You can't really keep on carrying it forward. You're supposed to take it. There's still maternity leave. There's still sick leave. The nursing leave for mothers who've delivered children is slightly reduced, actually. There's parental leave that was there before, actually. There's bereavement leave. So there are some provisions that were kind of carried over from the previous law. If you recall, the previous law was amended several times, especially in the past 4 or 5 years. And a lot of these things were put in through amendments, but now they're in one place, okay? But again, no big change really in terms of leave entitlements. Again, there are official holidays that are listed. Let me move on to the next slide. Oh, sorry, let me answer that question, Kay. 30 calendar days. Annual leave has always been 30 days, and it's 30 days, it still is. Some companies calculate annual leave based on working days. And if you do that, if you have a 2-day weekend, then basically 22 working days is equal to 30 calendar days. But the UAE labor law uses calendar days to count it. And I know a lot of companies can't really adjust to that because they have working days as their worldwide baseline. But for me, it's always easier to calculate it using calendar days. And again, like before, if there's a weekend during your annual leave, it doesn't extend the leave. If there's a nice, long holiday in the middle of your annual leave, it doesn't extend the leave. It's just 30 days in a row as the calendar moves. Okay, let's move on now to the next one which is really just a summary slide up here. This is something worth watching, folks. The labor law does allow, it contemplates that some persons in the labor market are going to be working part-time. Some will be working flexible working hours. Some might be temporary. There's some might be working for this employer 4 hours a day and that employer 3 hours a day, gig economy kind of thing. Some will be self-employed, and regulations are promised to address these issues, to flesh it all out. But it's always been a bit of a problem with the labor law because entitlements just accrue as if everyone's a full-time employee and all the rest of that. But I think there's going to be some flexibility now going forward, which will be again, detailed in regulations, which we don't have yet. But just watch this space. I think there are going to be some interesting changes in sort of modernizing the labor market here in the UAE. It's already changed quite a bit. With COVID, many people are working from home. There are people I know who are working remotely. They work in Dubai, but their employer is somewhere else. A lot of people have adopted flexible working hours because that's what's demanded. And even with the new work week, we still have to be able to deal with, Europe, which is 3 hours this way, and Japan, which is 4 hours that way, and America, which is 10 hours the other way. Flexible working hours is kind of like the way things are. And the labor law is going to have some regulations that will address all the kind of unique issues that come up. Let me move on to the next one, please, Samara.
Actually,
Oh,
Charles,
yeah, is there a question? Sure, go ahead.
There are a couple of questions that are related to leaves, and I thought maybe we could
all
address
right.
them now.
Okay.
One of them is about, are women employees eligible for maternity leave during probation? That's one question.
Yeah. I think that's a good question. If I recall correctly, hang on, I'm going to look it up. But I recall that the answer is yes, because it didn't used to be that case. I think it did change. Can I give me a second? That's one question. Is there another one?
Are there provisions giving new mothers nursing breaks?
Yeah.
Yeah,
there is. It's the nursing breaks. The only difference really is it used to be 18 months. Now it's 6 months. So it's not as generous as before. But the rule is this: a nursing mother, a new mother, recently given birth to a child, has the entitlement to up to 2 breaks per day to nurse the infant. I think the total cannot exceed 1 hour. And that's an entitlement. And it used to be, it continued for 18 months following childbirth. Now it's 6 months, but it's still there.
Okay.
And the question about maternity leave, if I remember correctly, I'm trying to look for it here. Here we go. Yeah, I mean, it used to say you only got it. Yeah, before it only began to accrue once the woman passed the probation period, but that's not the case anymore. So if you employers out there, if you hire a pregnant woman, she's going to get maternity leave even if she delivers within 6 months. So that's how it is. Okay.
Okay, and one more,
Yeah.
just one, can compassion leave be taken at a later time if employee cannot travel at the time of death of relative? Can the compassion leave be taken or delayed? Like,
yeah, I mean, yeah, I don't believe there's a specific, there's a cap on how much leave you get, and there is also, hang on a sec. Looking it up because I always look things up. Compassionate leave. Commencing from the date of death. Well, okay. The answer is no. Okay, that's what the law says.
so you have to take it.
Yeah, it's 5 days for the death of a spouse, 3 days for the death of a parent, child, sibling, grandchild, grandparent, commencing from the date of death, Article 32. So there you go. Now, most employers won't be quite that rigid in practice, but it is a question of employer policy, not a question of what the law mandates. So, and it was, and before there was no bereavement leave, so it's good to have something, but it's not, it doesn't mean you can wait a week or wait a month and then go on bereavement leave. No, it's within, you know, the time counting from death of the family member. Okay. Anything else that we can address now, or shall I go on?
You can go on. I just changed the slide.
Okay, we're going to just discrimination at the moment. Maybe I'll go through the rest of these pretty quickly because we're coming up, and I want to leave time for more questions later on. Discrimination. Can we go back one? Yeah, there we are. Okay. As a lot of you know, I think it was against the law previously to discriminate, and that is still the case. Only the difference now is it's all in one place in the labor law, not scattered among a different set of amendments. But let's see. I like the way it's worded here. Discrimination among employees on the basis of race, color, sex, religion, national origin, social origin, or disability is prohibited. There are also specific provisions on hiring the persons of determination, you know, disabled people, and it particularly addresses discrimination that tends to weaken access to opportunity or employment or continuation of employment or enjoyment of rights. So none of these, you know, invidious kinds of discrimination really are supposed to be permitted any longer. I know they go on, but I kind of hope that in, you know, a responsible employer will try to eliminate them. You still see in the market all the time, you know, wanted male accountant from India. You know, can you do that? Can you specify a male accountant from India as the employer you're looking for? You probably can't do that anymore. And so I think those kinds of things are going to be phased out in the years ahead. They are no longer consistent with the law. I remember years ago, not so long ago, I used to say that discrimination in hiring, nothing wrong with it, because once the employee becomes an employee, you've got to treat them fairly. But before then, you don't. That's not true anymore. You've got to be fair in hiring too. So discrimination in the workplace and discrimination in recruitment practices, you can't do it. So the only thing you can do is favor UAE nationals. Of course, they're given a preference in hiring, and there are some procedures for all of that. And there are special rules in terms of once they're employed by the company, what you can and cannot do. But that's the only discrimination that's still permitted. All of the other things that were done, widely practiced, are no longer consistent with the law. And so they should be phased out. Especially in light of the, I'm not going to talk about them in great detail, but there are much higher penalties now than before. So when the inspectors come along and subject you to a penalty, it can be, you know, a bigger pocketbook hit than you are used to. Go ahead next. There have always been provisions in the labor law that allow an employer to tell an employee or to stipulate in the contract, after you are finished, after you're no longer working for us, you are prohibited from working for anyone who's a competitor of ours, subject to things like reasonable time, business and geographic restrictions, and that's continued. The law now says it's 2 years is the maximum duration of these things. Whether they're going to be enforceable as a matter of practice is going to be something to look at, but it might be that the UAE labor law, the authorities want to enforce these because they put a time limit on them now. But one thing to bear in mind is that these restrictions, and these are kind of like the confidentiality and employer property and all the rest of these, they've got to be in the contract. They don't exist by force of law, they exist by force of contract. So if you do have employees you're hiring that you don't want to have leave you and go out and compete with you with another employer later on, getting hired away, you've got to put in the relevant restrictions in the contract when you hire. Okay. Does the non-compete make it easier for the employer to enforce in courts? It might. If you don't have it in the contract, you can't enforce it at all. So you need it in the contract. The law, I think, recognizes that these things are enforceable in principle. It's just the question of actually getting there that can be difficult sometimes. Next slide, please, Samara. What has happened over the past couple of years? So the one before that, the, number 12, that's it, yeah. What's happened over the past couple of years is that employment and residency have become decoupled, okay? What do I mean by that? Many people now, thousands, foreigners, live in the UAE and they aren't sponsored by their employers. They have golden visas or green visas or investment visas or property visas or something else like that. So when you hire one of these people as an employer, you can just hire them like that and that's all? No, you've got to go through the process of obtaining for them a labor permit through the Ministry of Human Resources, just like any other employee. And you sign a contract, file it with the ministry, get a barcode and all the rest of that, and go through all of the normal formalities of hiring a person under the labor law. Don't hire a person without obtaining a labor permit. If you do, that's a violation for the employee and for the employer, and you can both be subject to fines. Don't think that just because a person has a visa means that there's no labor permit requirement. Some free zones in the UAE, I think, are getting their procedures in place to approve the employment of these people that don't have employment-based visas. But here on shore, the Ministry of Labor is perfectly happy to issue a labor permit to somebody with a golden visa, for example. So again, do make sure that as an employer, you're following the rules and you're getting employment permits for all these people, okay? It is the Ministry of Labor process, not just the Immigration Department process, okay? Bapsi Dasturda, all panelists, yes, to answer your question, yes, if you hire an employee and the employee holds a golden visa, okay, you must obtain a labor permit for that employee. Labor permit is required. The visa is one thing, the labor permit is a different thing, and it is a requirement. Yes, Samara, are there more questions?
No, just another, what about freelancers?
Well, what about freelancers? Freelancers, a freelancer works for you work for yourself. And some people use that term kind of carelessly. But let's say, we used to have a computer guy with his own business. He worked for himself. He was a freelancer. He had his own business, okay, with one employee in, I don't know, Ras Al Khaimah or who knows, somewhere. And that company, that entity he had, then would contract with its customers, and the employee would go around and serve the customers. But that's not really freelancing. That person is a permanent employee. He might think of himself as a freelancer, but in fact, he's employed by his company, and that company has service contracts with its clients. So that, in that case, he has a visa, he has a labor permit, and he's got then service contracts with the clients of his company. That kind of freelancing is okay. If someone has a visa without a company sponsoring it, and there are a lot of people like that, like the golden visa holders. If you hire one of those as an employee in your company, yes, you must obtain for that person a labor permit. If you hire them part-time or on a gig, you still have to do it. And like I said before, there are going to be some regs coming out in terms of part-time employment in the gig economy. We'll have to see how those come out. But the general rule is the labor permit's required for everybody, even for employees whose visas you don't sponsor. You still have to obtain for them a labor permit. Okay?
Okay, great.
All right.
And there's one more, I don't know, I'm conscious of time, but if somebody's hired on a part-time basis with multiple employers,
yeah,
who sponsors that?
Yeah,
employee?
there are rules on that right now. And one of them is that the one employer has to sponsor the person, gets an employment. Well, usually one employer will sponsor the visa, get the health insurance, get the labor permit. But there'll be a filing with the Ministry of Human Resources that allows the person to work for other employers as well. It can be done. It's regulated. So you don't just go off and do it. You do it with the approval of the authorities. So that, again, there are going to be details in the regulations, but that's kind of, if you recall, there was a ministerial resolution, about 3 years ago on part-time employment, and addressed exactly this issue, so that someone could work for company A in the morning, company B in the afternoon. But it wasn't just like, it wasn't randomly done. You had to get approvals on the part of all three parties, both employers and the employee. And it was regulated by the Ministry of Human Resources. So very much part of the economy, but not one that's unregulated. Okay.
Okay.
Let me do this. We're getting a lot of questions. Let me just go through the remainder of this presentation in about 2 minutes. All right. And then I can take questions afterwards, because I want to make sure I'm addressing everyone's concerns to the extent I can. And I mean, I apologize that a lot of things really are going to be clarified by regs. So if I have to say over and over again, we'll see when the regs come out, that's what it means. We might have to come back and do this again when the regs come out. Okay, if you want to listen to me a month or two from now, we can do that. Coverage of the law. This to me is a big issue. No one else seems to think so, but I do. The exemption for agricultural laborers is done away with. Okay, that's not a big deal. Domestic servants are still exempt. Government employees, armed forces, police, security personnel still exempt. What's interesting is that the UAE Labour Law applies in the private sector, and that's defined broader than before. Okay, it is defined so as to cover even establishments. It doesn't apply to government offices, so ministries and departments of the government. Those don't count. But what do count are establishments that are wholly owned by the government, unless the law that sets the establishment up or the company up expressly provides that its employees shall not be subject to the UAE Labour Law, but by some other, maybe the federal or the Emirate civil service regulations. I'm interested to see how that comes out. Can you imagine if there are many quasi-public sector companies in the UAE where the employees essentially are treated like government servants? And this signals to me that might change. Will it? I don't know. But it's an issue to watch, and it's maybe only interesting to lawyers, but it's an issue to watch going forward. Turn the page. Employers are subject to a bunch of requirements in the new labor law. One of them is to promulgate workplace rules that detail the disciplinary measures you can take against employees. I personally think this whole business about disciplinary measures is kind of old-fashioned, but if you want to have a list of infractions and a list of penalties, there's guidance in the law on that. There are even regulations from the early 80s on that subject. And if you do have them, make sure you've got a rule book that's been filed with the ministry, because it won't be enforceable otherwise. Deductions from salary, if those are part of your disciplinary measures, make sure likewise that the standards have been reflected in a rule book that you have lodged with the ministry and obtain their approval. It's important to do that if you want to enforce these things. I don't know a lot of employers who really do that. It's a little bit, that's kind of like the old-fashioned approach to the workplace that still is there in the labor law, but it's there. Okay, turning along, turning to the next page. Like before, if an employee wants to go to court and file a case in court, the employee must first go to the ministry and file a grievance. There's a mandatory grievance procedure, non-binding conciliation. Then the employee can go to court. The employee is employment. The court fees are waived up to a claim of up to 100,000 dirhams, not complete like it was before, but up to a pretty big amount. If the company goes bankrupt, or if there are other claimants against the assets of the employer, the employee claim gets priority for the employment entitlements. And it's pretty high priority. It's right behind the cost of the bankruptcy and government charges like taxes and stuff. It's the third level. So really, really, really high priority for employee claims against a bankrupt former employer. Next slide. There's a pretty interesting allocation of responsibility as between the Ministry of Human Resources on the one hand and the Cabinet on the other hand. The Ministry is the regulator. They go around and do inspections and register contracts and make sure people are following the rules. The Cabinet has kind of a policy role, and it's a big one now. This is typical of a lot of the new statutes in the UAE. A lot of them are giving the statutes are enabling significant legislative action. Significant executive action. And the Cabinet has a lot of power to promulgate regulations, to change regulations, and a lot of what the law really means to all of us here, employers, employees, and everybody else, is going to be a result of how the Cabinet moves forward with its implementing regulations. But the Cabinet has a big role to play. The executive has a big role to play in how this law is going to be implemented and what the law is really going to mean at the end of the day. Again, that's a nice issue for lawyers, maybe not for everybody, but I kind of like to, it's interesting to see how the UAE is changing its the way it governs the economy. And that is basically the end of my prepared remarks. I'm very happy to answer questions. We've got, what, 10 minutes or so left? Like I said, yeah, Samra, we can do this again if there's a lot of interest. And I think maybe it would be good to repeat this when the regulations come out, because there'll be more things to talk about then. But I can take questions now.
Absolutely.
No, yeah.
There are a lot of questions. I'm going to go, as you said, we're just going to spend, for those of you who can stay on for another 10 minutes, we'll go through some of them. And those that we can't go through, we'll hopefully answer them offline. So I'm just going to go back now to some of the, like the overtime. So the current labor law, as you mentioned, includes the word Friday. Overtime pay is escalated for work on Fridays. Does the new law eliminate the concept of different overtime rates for different days of the week?
Nope. Still there. 50% is the only difference is that it's not Friday. It's the weekly day of rest, whatever that is in your workforce. So if you're going to change your work week on Wednesday next week, and it's going to be Monday through Friday, then your day of rest, you're going to have 2 days of rest, Saturday and Sunday, right? And so when an employee who's entitled to overtime is required to work on those days, the overtime rules for the day of rest will kick in. And you can either give the employee a replacement day in lieu, or you pay them, I think it's time and a half. The biggest difference there is that now the overtime is based on basic salary, the overtime compensation. So it's a little bit less of a burden for the employers. I mean, before it was uneven, but now it's almost always a basic salary. But yeah, the concept is the same. It's not Friday anymore, but there will be a mandatory day of rest. You may choose to have 2 days of rest as an employer, but when an employee works in those days of rest, it's the old overtime rules you used to have, is time and a half basically, those apply.
Okay.
Okay.
So if a company has 22 working days of annual leave, do they have to change the policy to 30 calendar days now?
No, it's not required. That's one of these. It's just, to me, it's well, in fact, 22 working days is going to be better for most employees. I mean, I'm assuming the company has a 5-day work week. If the company has a 6-day work week, then you should really have 24 working days, I think, for the right, or 26. I can't count. Yeah, 26. But if you calculate annual leave and the result is at least as good as for the employees as the law requires, then you're okay. So 22 working days is usually going to match 30 calendar days. Some days, some years it might be better, depending on when other holidays fall, things like that. But that'll be okay. And we've been to the ministry and asked these questions, and it's been they're fine with that, as long as it doesn't, shortchange the employees somehow. The authorities are okay with it. They're not mandating that you've got to go to 30 days and not 22 working days. That's not the mandate. The mandate is to comply with the law.
Okay.
All right, does that help?
Yeah. So another question related to hours and extra hours and overtime. Are exemptions approvals given by the Ministry of Labor for companies in the service industry to work an extra hour per day still valid, or do those companies need to reapply under the new law?
Yeah, there are two answers to that question. The short answer is no. That provision about retail and there was one category of employer that was allowed to keep their employees on the job for an extra hour a day as a matter of routine, like a blanket provision, and that has not been continued. But there has been scope given to the cabinet through implementing regulations to detail the rules on overtime. And so we have to, I warned you, we have to wait for the regs to come out. But what could they might talk about this, retail and food services and things like that, where people typically work, more than, an 8-hour day. I think they're going to also address executives, so-called white-collar employees, because professional employees generally, the ones that everyone knows that nobody works an 8-hour day anymore, or a 40-hour week anymore. That's long gone. Now maybe in some parts of Europe they're going to a 35-hour week, but I don't see that happening here, at least not in the private sector. And I think the regs are going to address that. What do you do with employees who are expected to work longer hours and to work more days of the week than everybody else? There are categories. Before, it was a very narrow category of employees who were exempt from the overtime rules. Is that going to stay the same? Will it be enlarged? Will it be shrunk? Will it be reconfigured somehow? That's what the regs are going to address. Plus the issue about retail and I don't think they're going to talk about offshore workers like before. That was kind of an unusual category. But we'll wait for the regs and then see how they really do affect the economy as a whole.
Okay. This is a question about workplace rules. Since the new law allows employers to develop workplace rules, including rules and procedures on disciplinary sanctions,
right?
How can we validate to avoid conflict of the existing laws?
Yeah, there's, I guess, two ways to do that. Well, one important well, you can review them, compare them with the law, make sure they're consistent. We're doing that for some of our clients. I'm not trying to pitch for work here, but someone in your HR or legal department should be looking at that. But that's just to make sure that it makes sense. It's important to communicate workplace rules to the workforce. The old law said you've got to post them in a prominent location in the workplace. Nowadays, no one really does that. There's not a bulletin board by the water cooler, but there's the firm intranet, right? So you can make sure that everybody has it on their screen and knows what those rules are. It's important to communicate them to everybody. And the ministry also does, the regs do say that, not the regs, but the law says that if you want to make sure that workplace rules, especially the sanctions that can be applied for violations, for breaches, if you want to make sure those are enforceable, file them with the ministry and get the ministry's approval. So they're part of your file down there. That means submitting them in Arabic and English, or just in Arabic. And that's burdensome, I know, if you've got one of these, workplace guide books like this, but that's the way to be sure. Have it filed with the ministry. But sometimes, the workplace rules are really more like a statement of corporate vision and culture. not so much as a statement of what we can do if you don't measure up, because that isn't really the way things are any longer. So maybe you could have just a really small booklet on discipline that you could file with the ministry and to be certain about enforceability. Well, certainty is the wrong word to use. To try and make it as likely as possible that it will be enforceable if challenged.
Okay, I'm just going to have one more question, Charles, because I'm conscious of time. Do companies have to amend all employment agreements entered and signed under the previous law? Do you need to amend all employment agreements?
Only in respect of the term.
Okay.
If a contract is in place already for a specified term, then you can leave it alone. Just keep it the way it is. Don't give yourself extra work. But the ones that are for unspecified terms, those need to be replaced. And someone asked about the forms the Ministry of Labor has. I don't know if they're out yet, but they should be. In fact, I think you can still use the old forms from the old labor law. Those were mainly, if I recall correctly, 3-year specified term contracts. So you could still use those. In fact, you could use one of the old forms and just tick the box for specified term, 2 years, 3 years, whatever. But that's what you want to do. The only mandated change is to substitute specified term contracts for unspecified term contracts. That's everything else is okay, but that's one thing you got to do in terms of paperwork. All right.
Okay. All right. Well, I think we can wrap up the webinar today. And as we've mentioned earlier, we will share the slides and the recording with everyone.
Yeah.
And if there have been any questions that have not been addressed, I know several questions have come in and they were addressed through the presentations or through other questions, but anything that has not been addressed, we will attempt to send you something privately offline. And I think you're right, Charles, we need to have another session in a couple of months.
Yeah, I think once the regs come out, we have a little more visibility as how things are really going to fall. We can do this again, because there's obviously a lot of interest, and we couldn't answer everyone's questions. So
yeah,
let's try and do that again. If everyone's up to it, I'm always game. Okay. Yeah.
All right. Well, thank you so much, Charles, and thank you everyone for your time today. This has been very, very well done, and hope to see you again in person and virtually. Thank you.
Thank you very much. Bye.